The judge handed my ex-wife the keys to our house on a Thursday afternoon in September. I watched her accept them with a smile so smug it made my teeth ache. Her lawyer, a pit bull named Marcus Sterling, who charged $200 an hour, shook her hand and said loud enough for me to hear, "Congratulations, Mrs. Brennan. You've earned this." My ex-wife, Diana, turned to look at me across the courtroom with triumph in her eyes. She'd won our 4,800-square-foot home sitting on 12 acres of pristine Oregon forest land. The house was worth $3.2 million, according to the appraisal her lawyer had commissioned. She'd gotten it outright, no buyout, no split. The judge had called it equitable compensation for 35 years of domestic labor and career sacrifice. Diana practically floated out of the courthouse. She moved her boyfriend into our bedroom that same weekend. What Diana didn't know, what her phone 200-an-hour shark failed to discover, was that the land beneath that house wasn't hers. It never had been, and I was about to prove it. My name is James Brennan. I'm 68 years old, and I spent 40 years as a commercial real estate developer in Portland, Oregon. I built strip malls, office parks, residential subdivisions. Nothing glamorous, but profitable and steady. I retired at 65 with enough money to live comfortably, a paid-off house, and what I'd believed was a solid marriage. I was wrong about the marriage, but I was dead right about the property, because that 12 acres of Douglas fir and cedar had been in my family since 1891. My great-grandfather, Samuel Brennan, had filed a homestead claim on 160 acres of Oregon forest during the tail end of the Homestead Act era. Over the generations, the Brennan family had sold off portions, subdivided others, but 12 acres, the heart of the original claim, remained protected under a family land trust my grandfather established in 1948. Diana had lived on that land for 35 years without understanding she'd never owned it. Her lawyer had spent 8 months preparing for our divorce trial without discovering the legal landmine buried in the property records, and I'd waited until the perfect moment to detonate it. The land came to me when I was 33 years old. My father, Robert Brennan, died of a heart attack in 1989 while fishing on the Deschutes River. He was 61, too young, and his death devastated me. Among his papers, I found the deed to 12 acres in the Coast Range foothills, about 40 miles west of Portland. The deed was unusual. It referenced the Brennan Family Land Trust, established 1948, and listed my father as trustee. I called the family attorney, an elderly man named Howard Mills, who'd handled Brennan family matters for 4 decades. Howard explained the trust's history. My grandfather, Daniel Brennan, had watched the Depression wipe out families who'd lost their land to taxes and debts. In 1948, he'd established an irrevocable land trust to protect the family's remaining acreage. The trust held the land separately from any improvements built upon it could only be transferred to direct male descendants, and specifically prohibited sale or transfer outside the family line. "Your grandfather was smart," Howard had told me in 1989. He understood that land outlasts everything: marriages, businesses, lifetimes. This trust ensures the Brennan name stays on that property forever. At 33, newly married to Diana and working 70-hour weeks building my business, I'd barely paid attention. The land was just a nice piece of forest, a place to eventually build a house, a legacy for future kids. I didn't understand then that my grandfather's paranoia about protecting family land would save me from my wife's betrayal 4 decades later. Diana and I married in 1987. She was 26, I was 31, and we met through mutual friends at a Portland Trailblazers game. Diana was beautiful, tall, blonde, athletic, working as a pharmaceutical sales rep making decent money. I was a hustling young developer trying to build my first major project. We dated for 18 months, got engaged at Cannon Beach, and married in a small ceremony in Hood River. For the first few years, we both worked. Diana traveled for her sales job. I worked insane hours on development projects, and we lived in a condo in the Pearl District. When Diana got pregnant with our son Jason in 1990, we started talking about building a real home. That's when I remembered the 12 acres. Diana and I drove out to the property on a sunny Saturday in May 1991. The land was stunning. Old-growth Douglas fir, a seasonal creek, views west toward the Coast Range. "This is perfect," Diana breathed. "We could build our dream house here, raise Jason in the forest, have more kids. This is everything I wanted." I was thrilled she loved it. We hired an architect, designed a sprawling contemporary home with walls of glass and cedar siding, and broke ground in spring 1992. The house cost $680,000 to build, a massive sum in 1992, and we financed it with a construction loan of $500,000 and $180,000 from our savings. The title paperwork listed James Brennan and Diana Brennan, husband and wife, as joint tenants with right of survivorship. We moved into the finished house in October 1993, 3 months before our daughter Emma was born. What I didn't understand then, what wouldn't become clear until 2025 when everything fell apart, was that the house title and the land title were separate legal entities. The Brennan Family Land Trust owned the land. James Brennan, as trustee, controlled the land. But James and Diana Brennan jointly owned the structure sitting on that land. They were two different pieces of property that happened to occupy the same physical space. Our marriage was good for a long time. We raised Jason and Emma in that house. I built my development business into a successful firm with 25 employees and projects throughout Oregon and Washington. Diana stopped working when Emma was born and became a stay-at-home mom, which was her choice and something we could afford. We had the Pacific Northwest dream life: hiking, camping, skiing at Mount Hood, summer beach trips to Manzanita. Jason graduated from Oregon State, got a good job in Seattle. Emma went to Portland State and became a teacher. We'd done it right, or so I thought. Diana was apparently keeping score in ways I didn't understand. The problem started about 7 years ago when I was 61. Diana, then 59, suddenly decided she needed to rediscover herself. She started taking yoga classes, joined a book club, enrolled in community college courses on art history and creative writing. I was supportive. Diana had spent 25 years raising our kids, and now that they were adults, she deserved to explore her interests. But the self-discovery quickly morphed into something else. Diana started dressing differently, younger, trendier, tighter clothes. She got highlights in her hair, started wearing more makeup, bought a new wardrobe. She lost weight and spent hours at a boutique gym in Portland. At first, I thought she was going through a phase, trying to feel young again. I should have realized she was getting ready for someone else. The someone else was Craig Donovan. He was 52 years old, divorced, owned a craft brewery in Portland, and drove a vintage Land Cruiser he'd restored himself. Diana met him at one of her community college classes. He was apparently getting a business degree at 52 because it's never too late to learn. They became friends, then study partners, then more. I found out about the affair 2 years ago when Diana accidentally left her phone on the kitchen counter and a text from Craig B. popped up. "Last night was incredible. I can't stop thinking about you. When can I see you again?" I'd stood there staring at that text for probably 5 minutes, my brain refusing to process what it meant. Then I scrolled through their message history. 2 years' worth of texts, hotel meetups, weekend trips she'd told me were yoga retreats or book club excursions, explicit photos I couldn't unsee. 33 years of marriage reduced to a text thread full of lies. I confronted Diana that night. She didn't even have the decency to look guilty. "Yes, I'm seeing Craig," she said calmly. "I've been seeing him for 2 years. I'm in love with him, and I want a divorce." Just like that. No apology, no explanation, no emotion. "You're in love with him," I repeated, my voice barely working. "After 33 years of marriage, you're just done?" Diana shrugged. "James, I'm 62 years old. You retired 3 years ago and turned into an old man overnight. Golf, fishing, home improvement projects, that's your whole life now. You're boring. Craig is exciting. He runs a business. He travels. He makes me feel young. I spent 33 years being your wife and our kid's mom. Now I want to be Diana. Just Diana. And Craig sees me that way." "So you're leaving me for a 52-year-old brewery owner?" "I'm leaving you because our marriage is dead," Diana said. "Craig is just honest about what he wants. We connect in ways you and I never did." That stung worse than the affair itself. Diana wasn't just leaving. She was erasing our entire history. The divorce papers were filed 3 weeks later. Diana hired Marcus Sterling, a Portland divorce attorney with a reputation for being ruthless and expensive. Sterling specialized in representing wives of successful businessmen and had a track record of securing huge settlements. His opening offer was stunning. Diana wanted the house outright, 65% of our retirement accounts, $8,000 per month in spousal support for 15 years, both vehicles, and me out of the property within 60 days. She claimed she'd sacrificed her career to raise our family and maintain our home, that I'd forced her into traditional gender roles, and that keeping the house was essential to her emotional well-being and financial stability. Diana had stopped working by choice in 1993, made that decision jointly with me, and now was rewriting history to paint herself as oppressed. I hired an attorney named Patricia Huang, a 55-year-old Portland lawyer who specialized in high-asset divorces and had a reputation for being methodical and tough. Patricia charged $550 an hour, less than half of Sterling's rate, but came highly recommended by my business attorney. At our first meeting, Patricia reviewed Diana's petition and whistled low. "James, your wife is going for the throat. She wants the house, most of your retirement money, long-term support, and she wants you out immediately. This isn't an equitable split. This is financial warfare." "Can she get it?" I asked. Patricia considered carefully. "Oregon is an equitable distribution state. The court divides assets fairly based on multiple factors: length of marriage, contributions of each spouse, earning capacity, age, health. Diana has some arguments. She stopped working to raise your kids, your retirement accounts are substantial, you're both in your 60s with limited future earning years. But her demands are excessive. Most judges would split retirement 50-50, order limited spousal support, and either sell the house or have one spouse buy out the other." "What about the house specifically?" "That's where this gets tricky," Patricia said. "The house is your primary marital asset, appraised at $3.2 million, no mortgage. Oregon courts often award the family home to the spouse who has stronger ties to it. Diana can argue she raised your children there, maintained the property for 30 years, and has emotional attachment. You can argue you built the house, paid for it, and have equal attachment. It could go either way." That's when I remembered my grandfather's land trust. "Patricia, let me ask you something. The house sits on land that's been in my family since 1891. My grandfather established a family land trust in 1948 that holds the property separately from any improvements. I inherited trustee control when my father died in 1989. Diana and I built the house in 1992-93 using marital funds, and the house title lists both our names. But the land title is held by the Brennan Family Land Trust, which specifically prohibits transfer outside the family. Does that matter?" Patricia stopped writing notes. She looked up at me sharply. "Say that again, slowly." I explained the history, the homestead claim in 1891, my great-grandfather Samuel, the trust establishment in 1948, my inheritance in 1989, building the house on trust land. The house and land were always separate, I said. I just never thought about it, because I'm both the homeowner and the trustee. It's all me, so the distinction seemed irrelevant. Patricia was quiet for a long moment, then she started smiling. James, do you have the trust documents? In a safe deposit box at U.S. Bank. Original paperwork from 1948, transfer documents, everything. Get them to me today, Patricia said. If what you're telling me is accurate, Diana can't have the house, because she can't have the land, and a house without land rights is worthless. I felt something cold and sharp crystallize in my chest. Not hope exactly, more like possibility. That afternoon I retrieved the trust documents from the bank. The original 1948 papers were yellowed and fragile, typed on an old manual typewriter, but perfectly legible. My grandfather had been thorough. Brennan Family Land Trust. Established March 3, 1948. Grantor, Daniel Patrick Brennan Property. 12 acres in Yamhill County, Oregon. Legal description follows. Article 4. Transfer restrictions and beneficiary limitations. The trust property shall remain perpetually within the Brennan family bloodline, transferable only to direct male descendants of the grantor. No trustee shall have authority to convey, sell, lease, or transfer the trust property to any person outside said bloodline. Any improvement or structure placed upon the trust property shall be deemed separate property for all legal, tax, and marital purposes, and shall not create any right, title, or interest in the underlying land. Should any court or authority attempt to order transfer of the trust property in violation of these terms, such order shall be void, and the trust property shall remain with the then current trustee and bloodline beneficiaries. I brought the documents to Patricia. She spent 3 hours reviewing them with a property law specialist she brought in for consultation. When they finished, Patricia looked like I'd handed her a winning lottery ticket. James, this is incredible. Your grandfather created an ironclad perpetual trust that completely separates the land from any improvements. Diana can argue until she's blue that she deserves the house, but legally she cannot own or control the land it sits on. And without land rights, the house is functionally worthless. What does that mean practically? It means several things, Patricia explained. First, even if a judge awards Diana the house structure, she'd need your permission as trustee to continue occupying the land. You could charge her market rate rent, which for 12 acres in that location is probably $6,000 to $8,000 monthly. Or you could revoke permission entirely and require her to remove the structure. Second, the house cannot be sold to a third party without negotiating land rights separately. No buyer will purchase a structure without secured land access. Third, Diana's entire case is built on getting the house. If we can prove the house is unsustainable without your cooperation, her position collapses. When do we tell them? Patricia smiled. We don't. Not yet. Let Sterling and Diana continue building their case around the house. Let them invest months arguing why Diana deserves to keep it. And then, when we're in front of a judge, we drop this bomb. By then, it'll be too late for them to restructure their strategy. I'd been married to Diana for 35 years. She was about to learn that trying to take everything from me came with consequences she couldn't imagine. The divorce proceedings consumed the next 14 months. Diana and I continued living in the same house, me in the master bedroom, her in one of the guest suites. The atmosphere was poisonous. Diana's boyfriend, Craig, started showing up at the house for visits, parking his vintage Land Cruiser in my driveway like he owned the place. I'd come home from errands and find Craig and Diana in the living room, drinking wine, laughing, acting like I was the intruder. The disrespect was breathtaking, but I said nothing. Let Diana get comfortable. Let her believe she'd already won. Let her imagine Craig living in her house after the divorce was final. The mediation sessions were disasters. Sterling opened the first mediation with a 20-minute speech about Diana's sacrifices, her contributions, her rights. "My client spent 25 years as a full-time mother and homemaker," Sterling intoned. "She sacrificed a lucrative career in pharmaceutical sales, where she'd been making $70,000 annually to raise Mr. Brennan's children and maintain his home. She enabled his success, supported his career, and now, at 62 years old, she deserves to keep the home where she invested her entire adult life. Mr. Brennan has ample retirement assets to purchase another property. This is simple equity." Patricia countered with facts. Diana had chosen to stop working. The house had been built with my earnings and planning. I had as much attachment to the property as Diana did. The mediator, a retired judge named Kenneth Martinez, seemed sympathetic to Diana. "Mr. Brennan, your wife raised your children in that home for 3 decades. She's 62 years old with limited future earnings. Forcing her to leave seems harsh. You have significant financial resources. Why not let her keep the house, and you take a larger share of retirement accounts?" "Because it's built on my family's land," I thought. But Patricia had signaled me to stay quiet. "Your Honor, we're willing to discuss creative solutions, but Mrs. Brennan's demands, the house plus 65% of retirement accounts, plus $8,000 monthly support for 15 years, that's not equity, that's greed." The mediation failed. Diana rejected every compromise. She wanted the house and substantial financial assets, period. So we went to trial. The trial was scheduled for September 12, 2025, 16 months after Diana filed for divorce. The judge was Margaret Rodriguez, a 58-year-old Multnomah County Circuit Court judge with 15 years on the bench. Patricia described her as fair-minded but old school. She respects property rights and doesn't like emotional manipulation, but she's sympathetic to older women who stayed home to raise kids. That could cut either way. The trial began on a rainy Monday morning. Diana sat at the plaintiff's table with Sterling and an associate, dressed conservatively and looking sympathetic. I sat with Patricia wearing my best suit, trying to project competence and fairness. The optics favored Diana. She looked like a wronged wife fighting for security. I looked like a rich developer trying to keep everything for himself. Sterling's opening statement was pure theater. He spoke for 40 minutes about Diana's sacrifices, her contributions, her suffering. He showed photos of Diana through the years, young and career-minded in her 20s, then pregnant with Jason, then with baby Emma, then older as she devoted herself to family. "This woman gave up everything for her family," Sterling declared. "And now her husband, after 35 years, has discarded her for reasons we can only speculate about. The very least this court can do is ensure Mrs. Brennan keeps the home she built with her labor, her love, and her life." The affair was conveniently omitted from Sterling's narrative. Diana was the victim, not the cheater. Patricia's opening was simpler. She acknowledged Diana's contributions, but emphasized mutual investment. "I'd planned and built the house, financed its construction, paid the mortgage, maintained it for 30 years. Diana had participated in domestic life, but so had I. I'd coached our kids' sports teams, managed finances, handled repairs." "This isn't a case of one spouse exploiting another," Patricia said. "This is 2 people who built a life together and now must divide it fairly. Mr. Brennan has offered multiple reasonable solutions, including selling the house and splitting proceeds, or buying out Mrs. Brennan's interest. Mrs. Brennan has rejected all compromise because she wants everything. That's not equity. That's entitlement." Diana testified first. She was poised and emotional, telling stories about raising Jason and Emma, maintaining our home, supporting my career. She described picking out every detail of the house, paint colors, fixtures, landscaping, and making it a home through decades of effort. "I poured my soul into that house," Diana said, dabbing, "at tears. It's not just a building. It's where I raised my children, where I celebrated every holiday, where every memory of my adult life exists. The thought of losing it, of watching James give it to someone else, or sell it to strangers, it's unbearable. That house is who I am. She conveniently forgot to mention she was planning to move her boyfriend into her house the moment the divorce finalized. Sterling asked about the affair. Diana was ready. Yes, I became involved with Craig Donovan about 2 years ago. I'm not proud of it, but I need the court to understand. My marriage was over long before I met Craig. James retired at 65 and completely checked out of life. He played golf, fished, did projects around the house, but he stopped engaging with me emotionally. We hadn't been intimate in years. We barely talked. I was lonely, and Craig made me feel seen again. I should have ended my marriage before starting a new relationship, but emotionally, the marriage had already ended. 2 years of sneaking around, hotel rooms, explicit texts, reduced to, I was lonely. Patricia cross-examined. She was respectful, but pointed. Mrs. Brennan, you testified that you poured your soul into the house. But who designed it? James and I worked with an architect. Who selected the architect? James knew him from work. Who managed the construction project? James did. He's a developer, so who secured the construction financing? James handled the financial aspects. Who paid the mortgage for 30 years? Diana hesitated. James made the payments, but it was our money. Mrs. Brennan, you stopped working in 1993. Since then, your husband has been the sole income earner, correct? Yes, but I contributed by maintaining the home and raising our children. Of course, but in terms of actual financial investment in the house, the money used to build it, pay for it, maintain it, that all came from Mr. Brennan's earnings, correct? Legally, yes. Patricia moved on. Mrs. Brennan, you're currently in a relationship with Craig Donovan? Yes. And if you're awarded the house in this divorce, Mr. Donovan will move in with you? Diana's eyes flickered. We've discussed it. So this house that's supposedly filled with sacred family memories, you're planning to share it with your boyfriend? My relationship with Craig doesn't diminish what the house means to me. But it does show your attachment is less about preserving memories and more about maintaining a desirable lifestyle, doesn't it? Objection, Sterling said. Argumentative. Sustained, Judge Rodriguez said. But the point was made. The trial continued for 4 days. Sterling called witnesses who testified about Diana's community involvement, her parenting, her homemaking. He established that I had $3.7 million in retirement accounts, while Diana had just $350,000, a function of her not working for 30 years. He painted Diana as financially vulnerable and me as wealthy and unsympathetic. On day 5, Patricia called me to the stand. I testified about our marriage, our decisions, building the house. I was factual, calm, and prepared. Sterling's cross-examination was brutal. He hammered me on income disparities, on Diana's sacrificed career, on my forcing her into domestic roles, which was absurd. Diana had wanted to stay home. He tried to portray me as a controlling husband who'd benefited from Diana's unpaid labor and now wanted to discard her without fair compensation. Then Patricia called our final witness, Dr. William Thornton, a property law professor from Lewis and Clark Law School. Professor Thornton had reviewed the Brennan family land trust documents, the house title, the history of the property. He testified for 2 hours about the legal doctrine of severance, how land and improvements can be held separately, how trusts can restrict property transfer, how Oregon law recognizes these arrangements. Professor Thornton, Patricia asked, what would it mean if the court awarded Mrs. Brennan the house structure, but the land remains in the Brennan family land trust? Thornton was clear and unequivocal. It would mean Mrs. Brennan owns a structure with no legal right to occupy the land it sits on. She would be required to negotiate a land lease with the trustee, in this case Mr. Brennan, to continue occupying the property. If no agreement could be reached, she would need to either remove the structure from the land or vacate it entirely. And what is market rate for land lease in that area? Based on comparable rural properties in Yamhill County, approximately $6,500 to $8,500 per month. The courtroom went dead silent. Diana's face drained of color. Sterling was frantically flipping through papers, clearly realizing his entire strategy had just collapsed. Judge Rodriguez leaned forward, suddenly very interested. Patricia entered the trust documents into evidence. The 1948 original, the transfer documents from my grandfather to my father to me, the deed showing the Brennan family land trust as the landowner, separate from the house title listing James and Diana Brennan. She explained that when we'd built the house in 1992, we'd never formalized a ground lease because I was both the homeowner and the trustee, essentially leasing to myself. But that arrangement, Patricia said, was based on our marriage continuing. If Mrs. Brennan takes sole ownership of the house structure, she has no automatic right to the land. She would need Mr. Brennan's consent as trustee to occupy the property, and the trust terms require market rate compensation for land use. Sterling scrambled to respond. Your Honor, this alleged trust is a sham designed to hide marital assets. Counsel, Judge Rodriguez interrupted. The trust was established in 1948, 18 years before your client was born. It predates the marriage by 4 decades. How can it be a sham to hide assets from a marriage that didn't exist yet? Sterling, changed tactics. Then I request the court order Mr. Brennan to provide Mrs. Brennan a land lease at nominal rent, reflecting her decades of occupancy and investment in the property. Patricia stood. Your Honor, Mr. Brennan is trustee of a family land trust with fiduciary duties to other beneficiaries, specifically his children, Jason and Emma Brennan, who have contingent interests. He cannot give away trust assets without proper compensation. Any below-market lease would breach his fiduciary duty and potentially expose him to liability. Who are these other beneficiaries? Rodriguez asked. Mr. Brennan's children from his marriage to Mrs. Brennan, Patricia said. Per the trust terms, they have future beneficial interests in the property. Any lease that diminishes the trust's value harms their interests. Diana's face had gone from pale to ashen. She was understanding, probably for the first time, that her victory was unraveling. Rodriguez took a day to review the trust documents with her clerk. When we reconvened, she had questions. Ms. Huang, if I award Mrs. Brennan the house, but she cannot secure land rights, what happens? Several possibilities, Your Honor. Mrs. Brennan could negotiate a lease with Mr. Brennan as trustee, paying market rate. She could attempt to sell the house to a third party, but finding a buyer would be nearly impossible without secured land rights. No lender will finance a structure without land title. She could abandon the house entirely, or she could seek to remove the structure from the land, though that would be prohibitively expensive and leave her with essentially nothing. And if I award Mr. Brennan the house, then he retains both the structure and land rights as trustee, and the division would be straightforward. Mrs. Brennan would receive her share of other marital assets. Rodriguez spent another day deliberating. Her written decision came down on September 21, 2025. This court has carefully reviewed all evidence and arguments. The Brennan Family Land Trust is a legitimate, long-standing legal entity that predates the marriage by 40 years. The trust documents clearly establish that the land beneath the marital home is separate property, held in trust with specific restrictions on transfer and use. Mrs. Brennan seeks to be awarded the marital home as compensation for her domestic contributions to the marriage. However, the marital home consists of 2 legally separate components: the house structure, marital property subject to division, and the land, separate trust property not subject to division. This court cannot award Mrs. Brennan a house she cannot legally occupy without Mr. Brennan's consent as trustee. Awarding Mrs. Brennan the structure alone would be meaningless. She would face immediate eviction proceedings or prohibitive lease costs. Forcing Mr. Brennan to provide below-market land access would breach his fiduciary duties as trustee. No equitable solution exists that allows Mrs. Brennan to keep the house. Therefore, the court orders the following. 1. The marital home shall be sold to a third party at fair market value, with land lease terms negotiated between the buyer and Mr. Brennan as trustee. 2. Proceeds from the home sale, after satisfaction of any costs, shall be divided equally between the parties, 50 wives and 50. 3. Retirement accounts totaling approximately $4.05 million shall be divided 55-45 in favor of Mrs. Brennan, reflecting her longer period outside the paid workforce, $2.13 million to Mrs. Brennan, $182 million to Mr. Brennan. 4. Mr. Brennan shall pay spousal maintenance of $4,500 per month for 6 years, declining by $500 annually, total $282,000 over 6 years. 5. Mrs. Brennan shall vacate the marital home within 90 days to facilitate sale. 6. Each party shall bear their own attorney's fees. This division reflects Oregon's commitment to equitable distribution while respecting legitimate property rights established through legal instruments beyond the scope of marital dissolution. Diana's face crumpled. Sterling was already talking about appeal, but Patricia was smiling because she knew what came next. Diana couldn't afford to appeal, couldn't stop the sale, and couldn't change the fundamental fact that the land was never hers to claim. The house I'd built in 1993, where I'd raised my children and lived for 30 years, was going to be sold. But Diana's fantasy of keeping it and moving her boyfriend in was destroyed. The aftermath was messy and satisfying in equal measure. Diana hired a different lawyer to handle the sale negotiations. She tried to buy me out of my half of the house structure, appraised at $3.2 million. So her buyout would be $1.6 million, but she couldn't secure financing. No bank would lend her money for a structure without secured land rights. And I made clear through Patricia that any land lease would be market rate and non-negotiable. Diana then tried to force a sale at auction, hoping to get her $1.6 million quickly and move on. But she couldn't find buyers. Every potential purchaser's attorney discovered the land trust issue and backed out. Who wants to buy a $3.2 million house when you don't control the land it sits on? For 6 months, the house sat on the market with no offers. Meanwhile, Craig, the boyfriend who was supposed to move into Diana's dream house, got tired of waiting. He broke up with Diana 9 months after the trial, telling her, according to our daughter Emma, who Diana complained to constantly, that he wasn't ready for this level of drama and needed someone more emotionally stable. Diana was devastated. The affair that destroyed our marriage had been built on fantasies. Craig living in their house, Diana playing young and free, endless romantic adventure. Reality ruined it. 15 months after Rodriguez's ruling, I found a buyer, a retired couple from California named the Mitchells who had cash and understood the land trust complication. They offered $2.9 million for the house structure, below appraisal, but fair given the complications. I negotiated with them directly. They would buy the house for $2.9 million, Diana and I each getting $1.45 million. And simultaneously, I would grant them, as trustee, a 40-year land lease at $7,000 per month with 2.5% annual increases. The Mitchells were thrilled. They got a beautiful Oregon forest property with clear title to the structure and secure long-term land rights. Diana got her money and could finally move out. And I got $84,000 annually in ground lease payments flowing to the Brennan Family Land Trust for the benefit of me, Jason, and Emma. Diana moved into a condo in Beaverton and went back to work at 64. She got a job as a medical device sales rep, making $75,000 annually, plus my maintenance payments that started at $4,500 monthly and declined annually. She's dating someone new, apparently, another divorced professional closer to her age. Our kids maintain relationships with both of us, though they've told me privately they're disappointed in how their mother handled the divorce. The house, my house, the one I designed with an architect friend in 1991 and built with my own project management, is occupied by strangers now. I drive past sometimes and see the Mitchell's grandkids playing in the yard where Jason and Emma played 30 years ago. It's bittersweet. But every month, when the $7,000 ground lease payment hits the trust account, I remember that Diana thought she'd won. She thought walking into that courthouse and getting the judge to award her the house meant she'd destroyed me and secured her future with Craig. Instead, she learned that you can't take something that was never yours to claim. The house was marital property, yes, built with marital funds, titled jointly, shared for 30 years. But the land beneath it belonged to the Brennan family long before Diana existed, and will belong to the Brennan family long after we're both gone. My great-grandfather filed a homestead claim in 1891. My grandfather protected it with an ironclad trust in 1948. My father passed it to me in 1989, and someday it will pass to Jason and Emma. Diana took the house in the divorce, or tried to, but she couldn't take the land beneath it, and without that land, the house was just expensive firewood. My grandfather Daniel Brennan died in 1967, 2 years before I was born. I never met him, but his trust documents saved my life in 2025. He understood that land is permanent, that everything else, money, houses, marriages, even family relationships, can be temporary. He protected 12 acres of Oregon forest for 4 generations of Brennans, and that protection turned out to be the nuclear option I needed when my wife of 35 years tried to take everything I'd built. I'm 68 years old now. I live in a comfortable townhouse in Portland's Irvington neighborhood. My retirement accounts, post-divorce, total $1.82 million. The Brennan Family Land Trust generates $84,000 annually. I see my kids and grandkids regularly. I still play golf and fish and work on projects. I'm dating someone new, a 65-year-old retired librarian named Susan, who has her own money, her own life, and no interest in what I own. Diana's 64, working full-time, living alone, and, according to Emma, still bitter about losing the house. Her friends apparently ask her why she doesn't live in that beautiful house in the forest anymore, and she has to explain the whole complicated legal saga. I don't take pleasure in her misery exactly, but I don't feel guilty either. Sometimes people ask if I regret fighting for the land trust angle, if I wish I'd just let Diana have the house and moved on. The answer is simple: no, not for 1 second. Diana didn't just want a divorce. She wanted to erase me, take everything I'd built and install her boyfriend in the home I'd designed and paid for. She thought my decades of work, my family legacy, my grandfather's foresight, all of it could be overridden by a judge sympathetic to her sacrifices. She was wrong. Property law, trust documents, and a 77-year-old legal instrument saved me from a woman who thought she deserved everything because she'd stayed home to raise kids she'd wanted to raise, in a house she'd wanted to live in, for a marriage she'd destroyed with a 2-year affair. Diana took the house in the divorce, but I took the land beneath it, and the land, as my grandfather understood, is all that matters in the end.